do you, or anybody, do you see Manhattan School District number 3, tools for avoiding probate?
Yes.
Okay, good. I did it right then. So we will get started. I'd like to welcome all of you to this evening's program. Actually, this is our last one that we'll be doing for now. And my name is Marsha Goetting. I'm the Family Economics Specialist for Montana State University Extension. And in a normal year, I'm out doing programs. And I did one a couple of weeks ago, and I got to tell you, it was such a thrill to be able to see an audience for a change, because it's so difficult to do the webinars when you can't see the reactions of people. Now, you guys have been a little different because I've set you up in my meeting room. So last week, I got to see about 4 of you, and it was so neat because I could see your reactions. And that just kind of gives me a little bit of a high. I want to thank Jenny Francis for extending the invitation to me to do this series. And I realized it was the only one that was webinar-ish instead of live, but we thought we would experiment with that. And then I'd also like to thank you guys for putting up with yet another webinar. But soon, I'm hoping this is all going to be over and I'll get back to what I call the normal life of out there traveling and meeting Montanans. If you've been here before, you know that I like to use participant engagement tools. And the main one that we'll be using this evening is the chat room. And you can write questions in the chat room. I will ask you some questions and you can respond also in the chat room. So we'll see how that goes. The other engagement tool that I like to use is wildflowers. The names I want to use as key reminders for some of the important topics that we'll talk about. And for example, this happens to be a steer's head. Now, I'm sure if you look at it a little bit, you can see the ears, you can see the eyes there. I mean, what a gorgeous flower. But of course, it's not this big. It's only about a ½ inch. And if you're not careful, you'll step on it. But it's a beautiful flower to say, I want to steer you to an awareness of the various ways that your property can pass without the cost of probate. And our first example is a death canvas. Now, would you believe I actually used this for a get well card? I didn't know it was a mountain death canvas when I sent it, and I was so embarrassed when my best friend's mom wrote and said, you know, we lost 7 sheep in the Lima Mountains because of the death canvas. So it's not one to say, oh, it's not really important. It is. So what that makes me think of, though, is payable on death designations. Okay, payable on death designations can be used on any of the accounts that you have at a financial institution, such as your bank or your credit union. And what you're saying with the payable on death on these different kinds of accounts is you want it to go to the person that you have designated. And if you change your mind at any point in time, you can simply fill out a new payable on death designation. Now, your banks and your credit unions will let you have more than one, but the United States Savings Bond, the Department of Treasury, only says one. They're only going to allow you to have one POD. The advantage of a POD, of course, is no probate. So you could have $100,000 in a certificate of deposit, and that amount of money does not go through the probate process. So that makes more money that can pass to your heirs. All they will need is an affidavit that you have died and a government-issued photo ID, and voila, they get the money. You can POD to also not only people, but a custodial account. Let's say that you've got some children and they're minors, or maybe you've got grandchildren and they're under age 18. Well, you could POD whatever you've got to a custodial account for the kid, and then the kid isn't able to take it out until age 21. Now, I know there's only 3 years difference between 18 and 21, but we hope that the kid would be more mature at 21 than 18. You can also POD to a trust. You could have a testamentary trust that you established upon your death, and the children receive the funds in when you say so. And I had one lady at one of my meetings that she indicated she does not get her trust until she's 65. Amazing. She'll have a great, absolutely great retirement fund. But you could say 25, 35, or 40. Okay. So think about the Mountain Death Canvas. Think of PODs, payable on death designations, and take advantage of those. You can go out and do this tomorrow, and you've started doing your estate planning. And don't forget, you can change your mind at any point in time. Now, these are heart-leafed arnicas, and I found those in the Deer Lodge National Forest. And they remind me of Joe Hart and Brooke Hart. And they're doing heart-to-heart legacy planning. Now, Joe has heartfelt intentions, and what he's done is designated Brooke, his sweetheart and wife, as his POD beneficiary. Well, that's fine, except Joe later changes his heartfelt intention and he writes a will. And in his will, he says, I bequest that $100,000 CD to my son, Eric Hart. So this is my first question for you to enter your response in the chat room. Who's going to receive that $100,000? Is it going to be Brooke, the POD beneficiary, or is it going to be Eric because the will was written after the POD was done? So what do you think? Just, oh, somebody's raised a hand. I don't know what that means. I guess it means you're going to say something, and that's fine too. But I have here the whole screen, and so I can only see the chat when it comes up, you know, like magic for a second. So we're going to say, somebody says the will. We've got somebody says A. So we've got some differences of opinion here, and I'm glad I asked this question because here is the deal. It is going to be Brooke, his sweetheart, that receives a CD. Now you're saying, why? Wait a minute. The will takes control. No, it doesn't. You cannot undo a POD beneficiary with a will. So that's why when you have your will written, one of the things the attorney should ask you about is, have you taken advantage of some of these non-probate opportunities that the legislature has provided? And make sure that you're not doing something in your will that's different, because that part of it just won't be valid. Okay, so that's a CD there. So if Bill or Joe wants to change, all he has to do is go to his bank and his credit union, and he can fill out a new POD beneficiary form and then name Eric to receive the $100,000. Okay, now we're all going to do this together since several of you missed this question. And I bet some of you are old enough to remember Sing Along with Mitch. So that's what we're going to do to help you remember that you can't undo a pod with a will. So here we go. You can't undo a pod with a will. Now you know why I was not in chorus in high school. Oh my. So that is our sing-along. So do have a heart. Make sure that you are reviewing your beneficiary, POD beneficiary designations that you've put on your checking account, savings account, certificates of deposit, and your United States savings bonds. You know, we buy those and we tend to put them in the safe deposit box and forget them for the next 30 years. So take a look at those that you may have put aside from high school, graduation, or your wedding, whatever. Now this happens to be an albino fairy slipper. I had never seen one before, and I saw this in Yellowstone Park and I went, how exciting. Is it really a real? Yeah, it's a real flower. So of course I had to move it put it in my presentation. And you see the difference, what it looks like. A regular fairy slipper is this purple color. So which one's the prettiest? Yeah, I'll let you decide. So what we're going to do is look at the albino family in the early 1800s. So we've got mom and dad, they've got kids, then the kids had kids. So this is a situation with this particular family. Okay, so mom, we see that mom was the last one to pass away. And she had a $100,000 certificate of deposit. And we needed to say, hey, mom, did you look at the institution's form to see, did it say to my children by right of representation, or did it say equal? Okay, let's take a look at what that means. If it's right of representation, we can see that by the grandchild D. So grandchild D, grandchild D, we want to see our second question. What fraction is that child going to receive if it says right of representation? Is it nothing, 1/6, 1/7, or 1/9? So quickly tell me in the chat room. We've got an answer of 1/6. And we got another 1/6. We've got a 9th. So we got 2 1/6, 1/9. Okay, well, let me show you what the answer is. And indeed, it is 1/9. So what right of representation is looking at the number of children this parent had. And you can see they had 3. 2 had predeceased mom, but the third one didn't. So that's why that child gets a third, and a third of a third is what the green children get. And we've got one child, the turquoise one, that receives a third. Now, why did the pink children not receive anything? It's because the share went to the parent because the parent was alive. And try to explain to these grandchildren, they're saying, well, didn't grandma love me as much as she loved the others? Well, you can say that's the way Montana did it. But gee, if mom had written a will instead of using that POD and decided she wanted to treat her grandchildren equally, she could have done that as well. Or she could have simply put POD and named each of the grandchildren. So right of representation, that's what it means. You count the number of heirs, and then if there's any that is predeceased, their share goes down the tree. So that's why we have 1/9 for the green kids and 1/3 for the turquoise. Now, if mom had said equally to my children, different response. Because in this case, the only child she had living was the yellow sun. So he would receive all $100,000 of that CD, and the rest of the grandchildren don't receive anything. So it's very important that you look at the forms and see what the form said. Does it say by right of representation or equally? So the tip from the albino fairy slipper is Montanans need to understand the difference between right of representation and equally when it comes to having property go. Now, you can also find right of representation in a will. I often have people at my meetings that say, I don't need to listen to this part because I have a will. And I say, okay, does your will say right of representation? I don't know. Take a look. And if it does, Maybe that's what you want to have happen, but then again, maybe not. So just understand what those terms mean. Now here we have a meadow death camas. You know, when I was starting to learn these flowers, I thought, how am I ever going to tell the difference between a mountain death camas and a meadow death camas? Well, now I don't have a problem with that. But what that makes me think of is a TOD. And a TOD is a transfer on death registration. And that's used for stocks, bonds, and mutual funds. So what you're saying when you do a TOD is that I want it to go either to this individual or maybe these three individuals, and each of those individuals individually decide, do I keep the mutual funds or do I sell the mutual funds? So it transfers to the beneficiary without probate. So that is going to save your heirs some money for sure. And you can TOD to a testamentary trust that you establish upon your death. You can say, I want all of my assets to go into this testamentary trust. Then I want the income to be used for my grandchildren's education. And then when they reach 25, they get the whole thing. Or maybe at that point, you end up giving it to your favorite nonprofit. You decide. Now, I mentioned that the beneficiary is the one that decides whether to keep it or to sell it. So let's take a look at that. Somebody brave enough to say, if I gave you $1 million in stock, would you keep it or would you sell it? Okay, put it in the chat room. Would you keep it or would you sell it? Okay, I've got an individual, thank you, that said she is going to sell it. And when I do this meeting in the public arena, everybody goes, no, no, don't sell it because you'll have to pay taxes on it. And I get real smiley and say, because what happens is if I had, say, a $5 piece of stock, and when I die, it's worth $1 million, that $5 steps up to the fair market value. And so when the person sells it, there's no inheritance tax, there's no federal estate tax, and there's no capital gain tax. That's cool. So there is an additional saving for your beneficiaries. So you can use a TOD to control the distribution of your stocks, bonds, and mutual funds. That is a TOD. Okay. Now that you know about pods and TODs, is this something that you would add to your financial accounts? So I'm just curious, would they be yes, no, or you already have them? So tell me in the chat room. Yep, we've got some people that are going to do it. Yes, yes. Oh, and we've got some that already have them. Good for you. Okay. Do we have any questions up to this point in time that you want to ask while it's fresh on your mind? All right, let's, oh, you're on mute. Can I unmute you? I'll see if I can. Hold on. I'll have to stop sharing. I'll have to go back. I'm going to unmute everybody, but please don't have any barking dogs or screams. Okay. So evidently what it does is send you a request And then but if you can't, just go ahead and type in the chat room. Okay, I've lost my train of thought. What am I doing? I am going to share. Okay, we're back to the Explorer's Gentian. And this is a beautiful flower. And you see it in August. It's later in the year, and then that makes me want to explore a Todd with 2 Ds. A Todd with 2 Ds is a transfer on death deed. Okay, it's a way that you can convey your real property, regardless of cost, to one or more designated beneficiaries, and there is no cost of probate. So you could have a $6 million piece of property and you filed a transfer on death deed on it, and it transfers to your beneficiary, no probate of that. This became effective on October the 1st of 2019. Prior to this time, we had beneficiary deeds. So if you're an individual that filed a beneficiary deed, no problem. You know, that's still there. It's just now they're going to refer to them as transfer on death deeds. Now, the thing about a beneficiary or transfer on death deed is it's not your beneficiaries until you're dead. Okay, they can't use it as a collateral for a loan. They can't sell your property out from under you because, again, it's not theirs until you're gone. Now, let's explore where to record the transfer on death deed. You do that in the county where the property is located. So here in Gallatin County, we're going to file with the clerk and recorder's office. Okay, and we have available at the extension office, or you can download online, a Mont guide that tells you about transfer on death deeds. We also have at the estate planning site an example of a transfer on death deed. Now, if you're a land baron and you happen to have property in more than one county, well, you've got to file in 2 counties. So if you had land in Flathead and you had some other land in Richland County, you've got to file in both of those counties. Now, who can be your designated beneficiaries? Basically anybody. You know, your spouse, your children, your grandchildren, good relatives, good friends, and a trust. I mentioned the testamentary trust. Well, you could POD your house to the beneficiary or to the testamentary trust. And then you have rules in the document of the testamentary trust to say whether it should be sold or whether it should be kept for the kids or rented out. You know, you make the rules with something like that. Now, I want to explore a downside, though, that we did not know when that law was passed, is that title companies are refusing to issue title insurance for a year. And the reason is they fear that creditors might come out of the woodwork during that period of time, and they don't want to be held responsible for that. So that's one issue. Another issue just came up. We've got a court case where in Montana, there was someone that filed a beneficiary deed and died. And here's the house, and 3 days later, it burned down, burned to the ground. Okay, so the insurance company took the stance that the house belonged to the beneficiary upon this person's death. And that wasn't something the beneficiary thought to have insurance for. So that's something I'll definitely want to include in the Mont Guide when I update that, because that's pretty serious. I mean, who would have thought? Oh, yeah, well, yeah, and I can see the insurance company's viewpoint, but we're going to have to educate people to let them, have an awareness that that could happen. So bad case for who it happened to. Oh, that was my trigger to tell the story. Okay, so one solution that you could do is simply write a will, and you have the personal representative submit the will. And what happens then is notification in the papers is printed, and the creditors have 4 months to turn in any kinds of bills that are there. And so you might be able to do this quicker. The thing is, if the person wants to sell it, you're going to leave it to somebody that wants to sell it. They're not going to be able to sell it for a year because they can't get the title insurance. If they're not going to sell it, no big deal. So a tip from an explorer's gentian is really continue to explore if a transfer on death deed is something that would be appropriate for your situation. Now here we have a foxglove, and I'd like to provide you with a little bit more on Todd's. Outfox the law. What if you had a designated beneficiary die before you? That could happen. Husbands and wives travel in vehicles together. Thanksgiving, family members crawl into the vehicle, and oh dear, what if something happened? So what you can do is be foxy and specify a successor beneficiary. So let's look at Mark. Mark Fox has filed and recorded a transfer on death deed. And what Mark is saying is if I die, I want it to go to my son, Evan. But if Evan dies before I do, or at the same time, we want it to go down to Luke. And if you have a transfer on death deed, you can name more than just one beneficiary. In this instance, we've got Mark saying, I want it to go to Luke Fox and Lily Fox. Or maybe you would decide you want it to go to the Manhattan School District, and you could do that as well. So my tip from the foxglove is outfox the law by naming a successor beneficiary or a testamentary trust as your successor. Now here we have a blue flax, and I'm sure you've seen them. Okay, I got a question. Do we create pods and tods? And tods. A POD is financial, TOD is stocks, and TODD is the one with the transfer on death deed. So those all three have been created by the legislature to allow folks to transfer their property at death without it having to go through the probate process. Part of the instigation of this is the way fees used to be calculated. In other states, it's much, much worse than Montana. I mean, some states charge 10% of the amount that passes through. Well, Montana had a percentage. It was 3% of the first 40,000 passing through, and then 2% in excess of that. That was the maximum. But most of the attorneys were charging the maximum. So you might have something that just takes one piece of paper to transfer, like a deed. You do a quick claim and you get it to the heirs. Well, they're saying it should be now based on a reasonable cost. I don't know that I'm real fond of the reasonable business, but that's what the law says. It's no longer a percentage. Now, do we do this in addition to a will? No, the idea of a TOD is a substitute for a will, because you see, a will has to go through probate to be declared valid. So the intent of the legislature was to say, hey, what we're going to do is allow you to transfer as these things, POD, TOD, and TODD, without probate. So you might look at your situation and see if that makes sense for you to do a TOD or stay with the will. You can still use the will, no problem with that. So let's look at Gary Blue and his 2 Blue grandchildren. We got Linda Blue, we got Matt Blue. And what Gary has done is he did a transfer on death deed, and he named Linda Blue as his designated beneficiary. Okay, that's fine and good. But then later, Gary wrote a will. And in the will, he left the same property to his grandson. So you know what I'm going to ask, don't you? Who is going to get the property when Gary Blue passes away? Is it going to be Linda Blue? I got 1 vote for that. Or is it going to be Matt Blue? Okay, I got 2 votes for Linda. Another Linda. Okay, I don't think I really fooled you, because you know that, yes, it's Linda, because you can't undo a contract with a will. And you see that transfer on death deed is contractual, and a will cannot undo that. So you can imagine, oh my, Matt is saying, I get nothing. And you know, Dad wanted me to have it because he wrote the will. Well, what do you think Thanksgiving's going to be like in that family? Forget Easter, forget Christmas. Not going to work. Now, it could have been, and Matt's singing the blues because of what happened. And, we can understand that. But maybe Gary would have decided he wanted to leave it to the Manhattan School District. And he could have done that. And if he did, now we got Matt and Linda singing the blues because they didn't get it. So you can't undo a transfer on death deed with a will. And it doesn't matter. Was the will written years ago, or was it written after the deed was filed? The will cannot change a TOD. Okay. Now, this is a Richardson geranium, and you can tell there's little raindrops on it. And I got out to take this picture right after a rain, and I thought it turned out so good. But that reminds me of Granny Richardson. Okay. And one of Granny Richardson's estate planning goals is she wanted to support the Montana 4-H program. So she has a condo in Billings. And what she decided to do was contact the 4-H Foundation and say, hey, I want to give money to, or I want to do something. And she heard about the People Partner Grants, which kids and communities do to, build a bench out at the fairgrounds or put up a flag, or they do various sorts of things. So she filed a TOD with the clerk and recorder in Yellowstone County and made the 4-H Foundation as the designated beneficiary. And she specified that the proceeds from the sale will go into the People Partners Grants. And she's recognized at 4-H Congress by the 4-H Foundation for what she did. So see, it can be a nonprofit that receives your TOD, POD, or single D TOD. So TODs could be useful for helping a favorite nonprofit. Now, this is an evening primrose. And if you're familiar with flowers, you know that you better look at it while it's there, because tomorrow it's gone. As a matter of fact, that pink one there that's on the right, that was blooming yesterday, but not today. And what that makes me think of is Even Primrose. And he wants to name his son Evan as a beneficiary on his super duper pickup. Guess what? He can't. The legislature passed a new law that allows us to do this. So they call it the vehicle vessel situation. So we've got, let's define what those are. So it can be a motor vehicle, a trailer, a semi-trailer, pole trailer, RV, personal watercraft, sailboat, snowmobile. These are the things that all have title. And if we want to avoid probate on these items, we can take advantage of this new law that went into effect in October of 2021. And I'm working on a mock guide. I've got one from this group that has volunteered to review it for me. But if there's anybody else out there that would like to be a reviewer, I send it to you double-spaced, and you just let me know, am I using weird words in there, or does it not make sense, or whatever. I really appreciate the input of real Montanans when I'm doing a mock guide. But this form is available at the Department of Revenue, Motor Vehicle Department, and it's Form MV13. Okay, it's up on their website, and they allow you to apply for a beneficiary or to designate one when you apply for a title. And this is, for example, you're making a new vehicle purchase or you're purchasing another used one. So I happened to be buying a new car at the time, and I was so excited because I'm going to use this new form. So I filled it out and I gave it to our salesperson, and I got the title, no beneficiary designation. So we're still trying to work that one out. But it's going to take maybe a while for people to kind of get used to that. You can also, once you have a beneficiary and you want to add another one, you can do that. But the motor vehicle division is only going to allow you to have 2 beneficiaries on file, no more than that. Now, you can change a current beneficiary, and what they will do is change the record. And you see, that's what I'm wanting to see. Is it somewhere in the motor vehicle department, or is it printed directly on the title? So I'm still waiting. I'm still waiting to see what that will be. And then maybe you'll decide that what you want to do is simply revoke the current beneficiaries that you have on record. And you can do that with the MV13 as well. So again, if there's anybody out there that would be willing to serve as a reviewer, I would send it to you in an email attachment. So just give me your name and your email, and I'd be glad to send that out to you. Matter of fact, my goal is to have it done by Friday and out to the people to take a look at it. So the tip from the evening primrose is take advantage of this new law that we have in Montana and name a beneficiary for your vehicle and vessel. And you can use that form MV13. And once again, there's another item that does not have to go through the court process to get it to your beneficiaries. You've already named who you want to receive it. Now, these happen to be white mule's ears. Okay. And have you heard the phrase, mom and dad is stubborn as a mule? Okay. We're looking at an example here that we may have used in another one about dad and the mule, because I want to talk about joint tenancies. You see, I've heard again and again, I don't need a will because my husband and I have the property in joint tenancy with right of survivorship. And this is what Dad has done, is he married a new woman here. He has 2 kids, she has 2 kids. And you see, when he dies, she receives it all because the property was held in joint tenancy with right of survivorship. And you see, he wrote a will and he said, my 2 kids are going to get it. But no, the will has no effect. The property law, the contract applies. So when we have remarriages in a situation like this in Montana, people really need to take a look at, is joint tenancy the way we want to do this? Because we could be disinheriting our kids. As an example, let's say she gets it all and then she dies. Well, we've got a Mont guide that shows you what happens. You have to get the deceased person's name off, and you use this form, and we've got resources. But it could be, I'm going to go back here, and if she dies, it all goes to her children. So in this joint tenancy, he has unintentionally disinherited his kids, even though he thought he was providing for them. I'm sorry, I saw a question in the chat room, but it was so long I didn't have a chance to read it. So when I get through here, I'll go to the chat room and check that out. Okay, so joint tenancy really doesn't, well, it does avoid probate. I will say that. But you still need to get the deceased person's name off the document. I have a good friend whose dad died. And Mom, you know, it was joint tenancy, so gee, we don't really need to do anything. And I kept saying, you need to get your dad's name off of that because it's going to be a mess when your mom dies. Well, sure enough, Mom died outside of Montana in another state, and they're paying $5,000 now to get that handled when she could have done it simply with this affidavit and following the directions in our Mont guide. So remember, even though you have a joint tenancy, you do need to get the deceased joint tenant's name off of there. So my observation from the lady slipper is time has slipped away, but I want to make sure that you have opportunities to ask questions that you have, because I'm here. And if I know the answers, I'll share those with you, because everybody that's here kind of has a different aspect of what they're interested in. And I hope I've steered you to an awareness of the ways parents and grandparents can transfer property without the cost of probate. And then if you're really interested, I'm going to be doing some Wednesday wisdom programs for AARP. We're going to have one on April the 6th, May the 11th, and June the 8th. So those are at 10 o'clock in the morning, and you're certainly welcome to grab a cup of coffee and come on by. Now, if you don't have a memory like this elephant's head, yep, you can see the elephant ears, can't you? We do have 50 different Mont guide topics in the estate planning area alone. I have a lot of others in financial management, but those estate planning ones tend to be the most popular. And don't forget, your county extension office out there at the fairgrounds has these Mont guides, or you can download them from the web as well. So I'm going to quit sharing. Let's see if I can figure out how. There we go. And now we can open it up for, I'll take a look at the chat room here. Okay, can you put the counts in trust? Yeah, you can POD, TOD, or TODD. into a trust. Now, that's when you die. That is a testamentary trust. If you establish a trust while you're alive, then it's called a revocable trust. And so what you do is change the name of your savings account, checking account, your house from your name into the name of the trust. And then you have a trust document that says, this is how I want these funds to be dispersed, or maybe just hang out there for a while and earn interest and then be dispersed later on. But yes, you can POD to a trust. So you don't need to necessarily have the will and the PODs. I think a will's a good idea from the perspective, you may have some things you forgot to put a POD on. So a will would take care of that. And you see, it's possible to have a will and the will not even be submitted for probate because there is nothing for the will to probate. If you've used PODs, TODs, and TODDs, and our MV, vehicle or vessel, there's nothing for the will to control. So the attorney would probably say, we don't need to submit this will for probate because there's nothing it controls. Okay. Okay, can you use an MV on vehicles you own now or just when you buy? No, you can take advantage. I think what was happening in the motor vehicle department, they were afraid that they were just going to be inundated with people that's doing this. But most people don't know about it yet. And once I get the mock guide done, I'll do a news release and we'll get more and more information out there. But they were kind of specific about the certain situations where they would allow one. And that's why I'm really eager to get some reviewers for the mock guide, because a couple of people that had looked at this before said, look, I can't tell the difference between 3 and 4. I go, now that you mention it, I can't either. So that's why we need some input, believe me. Now, is a handwritten and notarized will good? Okay, let's take a look at what a formal will is. A formal will is one that is typed, software program nowadays. And what the attorney does is have you sign it in front of witnesses. And that's what makes the will self-proven, because those people are signing it as a witness saying you were of sound mind. So they go to this extra procedure for doing that. Well, if we have and that will is also notarized. Okay, so everybody is who they say they are when they sign the will. A handwritten will is legal in Montana. We're one of 3 states that have a holographic will. But, how do you know that you've said everything correctly? And sure, there's examples out there that you could use, but keep in mind, if it's going to be a holographic will, everything, and I mean everything, has to be in what we call the testator's handwriting. We had one gentleman, Western Montana, that wrote a holographic will on motel stationery. The judge rejected it. Why? What appears on motel stationery? Logo, telephone number, etc. So his response was, not everything was in the testator's handwriting. So let's not leave it up to somebody else to kind of make those kinds of decisions. I would have thought something like that would have been okay, but that's why I'm not a judge, I guess. Okay, I don't see any more questions. Anybody want to unmute? And I would be glad to answer those or add some more to the chat room. Oh, the web addresses. Okay. This is for, it's just as easy. If you're wanting, for example, Fabulous Fridays, that are a series of webinars, and all of those have been recorded. Okay, just in your browser, put Fabulous Fridays Montana, and they'll come up. Okay, if you're wanting Marsha Goetting's estate planning Mont guides, do the same thing. Just say estate planning Marsha Goetting, and you'll get probably more than you want, but there'll be Mont guides in there. And if this doesn't work for you, don't hesitate to just shoot me off an email and I can copy that. Oh, as a matter of fact, I should be able to do that. See, I'm not used to having control here. So I am going to show off and show you the address, and I'm putting it in the chat room. This is the address of the estate planning. Do you see it? Oh yeah, there it is. So those are where all 50 of the Mont guides are, as well as descriptions of each of those. And now that I've got this figured out, I'm excited. I'm going to give you Fabulous Fridays here. Oh, and if you should happen to have some grandchildren or, young families in your family, we did a 4-part series for estate planning for parents and grandparents raising minor children. And we tried to focus on the things that they were interested in. So I put that in the chat room too. Boy, this WebEx thing is cool. Okay, other questions? I'm just looking in the chat room, see if there's anything else I missed. I don't want to miss anybody. And another thing that I did this year, just to share, is I had a lot of people that were telling me, I don't have a computer. I don't have internet service that is dependable. So I put together a study at home course in estate planning. And we had what was called level 1 and level 2. And it was quite an experience. But I think, that Extension has a responsibility to reach out to people that don't have all these extra things and provide them with information as well. And they've been they've just really been a great group. We had over 200 enroll in our estate planning for every Montanan course. That was kind of fun. And I suspect that next fall we'll get around and we'll be doing some more webinars. But I also expect to be out on the road again, at least that's my hope, to present educational programs in the fall. We'll see what happens. Cross fingers. Well, we could sit here and stare at one another. Or we could say, hey, thank you. I certainly appreciate all of your participation in the series that we had here of the 3 meetings. And, let Jenny know what you thought about that. Or if you'd rather have live next time, we'll explore some options. And so in the meantime, if you see me around, say hi and say, hey, I was one of those Manhattan people that attended your program. So if nothing else, I'll say be safe and keep healthy. Thank you very much. Good night.